Good afternoon. Welcome and thank you for joining us today. My name is Loretta Besson and I am a retirement plan specialist at Gouldin McCarthy. Our entire team at Gouldin McCarthy would like to thank you for joining us today as we spend the next 30 minutes discussing the impact of the CARES Act on key retirement plan issues. I think we can all agree that we have been flooded with information over the last few weeks. And with so much uncertainty and confusion out there, we thought it might be helpful to open a platform for you all to hear directly from some of the leading ERISA experts in the country. We are grateful to be joined today by Steve Niehoff and Jason Roberts from the Pension Resource Institute and Dean Schoolar of the Retirement Law Group to help us understand this information. Just by a quick way of introduction, Jason Roberts is the Chief Executive Officer and Managing Partner of Pension Resource Institute and Retirement Law Group. Steve Niehoff is the Chief Operating Officer of Pension Resource Institute, an ERISA consulting firm supporting banks, broker-dealers, and RIAs. Steve has spent more than 20 years in our industry working in operations, compliance, and business development roles, both at PRI and at a large insurance company. Dean Schoolar is Senior Counsel at Retirement Law Group with a practice emphasizing tax and ERISA-related matters. Dean has over 20 years of experience practicing employee benefits law at the IRS with large record-keeping firms and with several private law firms. We are really excited to have these folks on the line and joining our call today. Steve and Dean will take us through the new rules and requirements and then give us an opportunity for some open Q&A. We are going to keep the lines muted during the call, and if you have any questions, please feel free to type those into the chat box, and we will address those at the end of the call. And with that, I'm going to turn it over to Steve.
Thanks, Loretta, and thanks everybody for choosing to spend some time on this call. I know there are a million things to do on any given day, and the current pandemic hasn't made that any less, but we do appreciate you spending some time with us today. The session here is relief for plan sponsors and participants regarding the CARES Act, and we've got a brief presentation that we'll go through, as Loretta mentioned, ample time for questions at the end. So the five key retirement plan provisions in the CARES Act, in order that we think, probably order of importance, there is a new distribution type. It's the coronavirus-related distribution, and we'll get into that in more detail. There's plan loan relief available for participants. There's the opportunity to waive required minimum distributions in 2020. If you think about the declining stock market, I know it's been up recently, but down from its high, forcing people to take distributions in that type of environment, there's some relief in 2020 that's available. For those of you who maybe have defined benefit plans or cash balance plans, there is some funding relief available for single employer DB plans. And the fifth bullet we'll be able to cover very quickly. The CARES Act granted the Department of Labor authority to postpone filing deadlines, things like the summary plan description, the summary of material modifications. While the DOL hasn't yet acted to grant any of that, any deadlines, they do have the authority to do so. So under the CARES Act, there are three different sort of ways that money would come out of a plan. And we wanted to prepare a summary chart because there's quite a bit of overlap, but there's also quite a bit of differences. So the coronavirus-related distributions, the plan loan relief, and the ability to waive required minimum distributions. Under the CARES Act, those are all optional provisions. We understand that different record keepers have different requirements and different notification requirements, but under the law, they're all optional. We would encourage you to work with Gouldin McCarthy to make sure that the record keeper requirements that you're hearing, make sure you run that back through Gouldin McCarthy and they can help you make sense of that. But the takeaway, just under the law, those are optional. Relief is available immediately. So if you choose to offer any of those things, you can offer them immediately. There's a broad range of plan types. The only real difference here is required minimum distributions can be waived from defined contribution plans under 401A, which does include the 401k plans. That's likely the largest number of plans from sponsors represented on this call, but also 403A plans, 403B, governmental, 457B, and IRAs. Although the relief is available immediately, a plan amendment is required, but it's not required immediately. So any plan sponsor that chooses to offer these, there has to be a plan amendment adopted on or before the last day of the plan year beginning January 1, 2022. And this last row here, that's really where some of the differences start to emerge. For coronavirus-related distributions, there's a set of COVID-19 requirements that participants must meet. The participant can self-certify for a coronavirus-related distribution. To take money out of the plan in the form of a loan, the enhanced loan relief, the participant can't self-certify. Whether that was intentional by Congress or whether that was an oversight that may be corrected or either through a technical correction or guidance, we don't know. But right now, under the law, participants can't self-certify that they meet the COVID-19 requirements for plan loans. And then with regard to waiving required minimum distributions, there are no COVID-19 requirements for participants. So then what are those qualifying participant conditions? For both the coronavirus-related distribution and the plan loan relief, individuals must meet one of the following requirements between January 1st and December 31st of this year. Participant, their spouse, and or dependent, if any of those people are diagnosed with COVID-19 by an approved CDC test, that participant is eligible for relief with the coronavirus-related distribution or the plan loan. So if there's a diagnosis that's impacting the family, that condition is enough. A second condition, if the participant experiences adverse financial consequences as a result of all of the things that we're seeing on the news, all of the things that we're seeing in our communities, and maybe even some of the things you guys are seeing with your plan. Financial consequences as a result of quarantine, furlough, layoff, reduced work hours, unable to work due to lack of childcare due to COVID-19. For business owners, maybe a business closure or a work hour reduction. If any of those things are true for the participant or the spouse, then that participant would qualify for relief for those two distributions. And this last one meets other factors as determined by the Treasury Secretary. We think that's kind of a catch-all. If you think about the pace with which the medical information has been changing and think about the pace at which the legislation proceeded, I think this catch-all existed to say there's a strong likelihood we're going to learn more in the days and weeks to come. Let's grant the Treasury Secretary, the ability to write other conditions as they become warranted as events change. So for someone who meets the requirements for a coronavirus-related distribution, up to $100,000 can be withdrawn, aggregated across all qualified plans, the 403A, 403B, governmental, 457B, and IRAs. Tax on the income due to the distribution can be spread over a 3-year period, and the additional 10% tax will not apply. Any amount distributed can be repaid into the plan or the IRA over the next 3 years, and those repayments aren't subject to plan contribution limitations. Coronavirus-related distributions do not have to satisfy any other plan-related distribution requirements. If a participant meets those requirements, that's sufficient to qualify. Distributions will be treated as an eligible rollover distribution for the purpose of allowing repayments. They will not be subject to mandatory withholding on traditional distributions from plans. As we mentioned, they can be adopted immediately, and they apply to distributions taken this year. Regarding the plan loans, relief can be implemented immediately for individuals that meet the requirements we discussed previously. For plan loans taken between March 27th, which is the date the act was signed into law, and September 23rd, which is 180 days from the date the act was signed into law, the maximum loan amount can be doubled from the lesser of $50,000 or 50% of the participant's account balance to $100,000 or 100% of the participant's account balance. And for participants who have a loan from their account with any payment due from the date the act was signed through the end of the year, the due date is delayed for 1 year and the term of the loan is extended for 1 year. Regarding the required minimum distributions, again, plan sponsors under the law have the option to waive required minimum distributions from defined contribution plans for participants that turned 70 and a half during 2019 and had not taken their distribution prior to 1/1/20. Amounts that would have been RMDs but for the CARES Act, which are or were distributed, are eligible rollover amounts that can be rolled over within 60 days without mandatory withholding. And again, there's a plan amendment requirement. Regarding the defined benefit funding relief, there's additional time. The headline here is you've got more time to meet funding obligations due in 2020. Those are now due January 1st, or can be due January 1st of 2021. The delay will apply to both contributions due in 2020 for 2019 or any quarterly contributions due in 2020 for plan year 2020. It's important to note that any contributions will be subject to the interest rate for that plan. So if the plan has a 5% interest rate assumption, delayed contributions will be subject to 5% interest. This one we talked about, DOL has been granted authority to extend deadlines, and as of today, they have not yet chosen to do so. So with that, I'd like to open it up for questions. Loretta, turn it back to you to help us get some questions.
Great. And Dean, did you want to chime in with anything before I jump to some of the questions that are pending?
Sure. A couple of key things on the required minimum distributions. It not only applies just for the people who turned 70 and a half in 2019. If you've got a 76-year-old participant who is taking required minimum distributions, they had to start a number of years ago, they're able to waive it also, provided that the plan wants to waive those as opposed to just continuing. This is a change very similar to what happened in 2009, where plans were allowed to waive that, and they could waive it either at the plan level or the participant could elect if the plan allowed for the participant to elect.
Great, thank you. All right, I'm going to jump into a couple of these questions here, and one is one that we have been seeing across the board come out a lot from our sponsors. Are sponsors required to send information to employees notifying them of the new COVID options if they have amended for the provisions? If so, what is that timetable?
Okay, if they have amended for the provision, the standard deadlines for summary and material modifications would be 210 days after the end of the plan year that they adopt the amendment. It's not a very helpful deadline because if you took your time and waited until July 29th of 2021 and told your participants then, hey, you can take this COVID distribution, they've missed the boat because you have to take the distribution by December 31st. The pure legal answer is yes, you have to give a notification by 210 days after the end of the year. The practical implication is you need to give notification, whether it be a less formal notification or a true summary material modification, as soon as possible so that you can get the information out to the participants so they can take advantage of it if that's the employer's intent by amending the plan.
Great, thank you. Next question we have, can you describe the pros and cons of a participant taking a coronavirus-related distribution versus a plan loan?
Sure. Coronavirus distribution is a unique distribution. This is the first time they've provided this type of relief, and it provides for a $100,000 distribution. The distribution, you don't have to be over age 59 and a half. You don't have to meet the normal restrictions that, let's say, a 401k would have that says, hey, you can't take it before age 59 and a half. You can't take it before you retire. None of those restrictions apply as long as the plan has adopted it. The other key factor is that the 10% additional tax that applies if the participant is under 59 and a half does not apply to a coronavirus related distribution. The ordinary income tax with a coronavirus related distribution is spread over 3 years if the participant elects to spread it. The participant on their tax return, they don't have to notify the plan sponsor. They can elect either to pay all the tax in 2020 or they can pay it over 3 years. And the big factor with coronavirus related distributions is that rather than having a 60-day rollover period, the participant has 3 years to put the money back into the plan. And if they've put the money back into the plan within 3 years, then it will be treated as a trustee to trustee transfer. It's not subject to taxation. If they do it at the end of the 3 years, they've paid tax at least 2 of those 3 years. There needs to be guidance from the IRS on whether you're going to get a credit on your 2022 tax return or whether the participant will need to amend their tax returns for 2020 and 2021 to get those taxes back. But essentially, they would have 3 years without having to ultimately pay tax on that money as long as they got it back in. With a loan, the increased loan, they're not going to have to make any payments during 2020, but starting in 2021, they'll have to make their normal repayments on this loan. And if they're still having financial difficulty, this could cause them to default on the loan. If they default on the loan, that deemed distribution does not qualify for waiver of the 10% additional tax, as well as it does not qualify for a coronavirus related distribution that could be spread over 3 years. So the participant would have to pay all the tax on that defaulted loan in 2021 when they default.
So, Dean, this is Dan McCarthy. Thank you again. So just so we're clear on the phone here, if a participant was looking to take a distribution, the optimal way to do that then would be through the coronavirus distribution rather than taking a loan from the plan from a tax standpoint. Does that sound right?
From my viewpoint, my recommendation is that the coronavirus related distribution would be the first place that I would be taking the money rather than a participant loan because of the adverse impact of that loan that could impact for a number of years, could create that adverse tax consequence, as well as could impact loans in 2023 when the participant needs to take a loan and lo and behold, they've got an outstanding loan that exceeds the $50,000 limit, which will go back into effect in 2021. So they couldn't take a loan at that time. So my recommendation would be coronavirus distribution first.
Got it.
Great. Moving to the next question, we know plan sponsors can implement these relief provisions today and amend the plan in a few years. Are there any best practices you would recommend to help plan sponsor manage updating their plan document when they are required to do so?
Communication.
Yeah.
Communication with the plan document sponsor, whether it be the record keeper, whether it be an insurance company, whether it be their lawyers who drafted the individually designed document, but communication to make sure that that is on the radar so they remember to get it amended. Communication with the participants, even though, as I said earlier, the summary of material modifications isn't due until July 29th of 2021. If they amended this year, they still need to communicate to participants so participants have the opportunity to take advantage of the changes. And the last recommendation is thoroughly analyze and decide what provisions you want, whether you want coronavirus and you want the waiver of RMDs, but you don't want loans, whether you want loans and nothing else, whether you want RMDs only. Thoroughly analyze and decide at the plan sponsor level what is best for your particular circumstances for that particular employer.
Great. Next question we have in the queue, could a sponsor be in jeopardy for not offering these beneficial tax distributions to participants who would qualify for a COVID distribution?
From an employee relations standpoint, yes, they are jeopardized because the employees, I'm sure, have been reading in the news, hey, you're entitled to this, go take it. But from a legal standpoint, this is what is called a settlor function, which means it's at the plan sponsor level where they determine whether we're going to offer this. And this is not a fiduciary decision. This is a settlor decision. And so it is not a fiduciary breach to not offer these. The statute clearly provides that these are optional provisions. Where you could run into problems is if you don't ultimately amend your plan, but you operated it as though you amended it, and you made distributions and the plan was never amended. That can be a fiduciary breach because you're not following the terms of the plan. But not offering it at all would not constitute a fiduciary breach.
Great. Last question we have here is, can you describe that self-certification in relation to the coronavirus-related distributions?
Sure.
We touched on that briefly.
With coronavirus-related distributions, the statute included a provision that allows for an employee to certify that they meet one of those three requirements, which would include my spouse or my dependent has been diagnosed, or I'm financially impacted because I've got reduced work hours, or my spouse does, or we're having to pay more childcare expenses. With the coronavirus related distribution, they're allowed to self-certify. Presumably, there will be a standard form that the particular record keeper will have that they'll want for that self-certification. The advantage of self-certification is that if the IRS comes in 3 years from now and does an audit on the plan and they see somebody took $100,000, you can take that form, show the IRS, Johnny signed this form, and the IRS can't do anything to the plan if Johnny was not qualified. Now, Johnny may be in trouble on his personal tax return, but the plan will not be. Plan loans, on the other hand, as Steve mentioned, did not have that same self-certification. So with plan loans not being able to self-certify. When a participant wants to take that loan and it's more than the original 50,000, or the plan didn't allow loans except for this case, they're going to have to provide more documentation, and unfortunately the plan administrator is going to be responsible for determining, did they satisfy the requirements? And the plan administrator, yes, they're probably going to rely on a record keeper, but ultimately when push comes to shove, will the record keeper support the plan administrator on actually doing the determination? So there's a risk with the self-certification not being with loans. With self-certification, I've been asked other times, hey, we have someone who's going to take a coronavirus related distribution. We know this person doesn't qualify, but they're going to give us the self-certification. What should we do? My recommendation is you step away from it. You allow them to self-certify, because the statute clearly allows you to rely on that self-certification. That participant could be in significant trouble with the IRS, but the plan would not be. If you take the opposing viewpoint and say, well, we know that they don't qualify and we want to investigate, and you investigate that one person but don't investigate anybody else, there's great potential for a discrimination claim that could come with doing an investigation where self-certification would be allowed.
Great. And one other piece that relates to plan loans, if a sponsor currently allows for only one loan in their plan, they would need to amend their loan policy at this time to allow for an additional loan if they're intending to allow the plan loan, the coronavirus plan loan?
That would be correct, and it could be a limited amendment. It could be, will allow you to take out a second loan during the period from March 27th to September 23rd. Will allow you to take a second loan only with regard to the increased limits, that sort of thing. So they could put basically a provision in that expires when this relief expires, and that way they don't have to go back in October and amend their plan a second time to say, now you can only have one loan.
Great, that's helpful. Thank you. That is all the questions we had in the queue, and I think as mentioned, obviously we are continuing to work with the record keeper partners and work through the mechanics of some of these changes. So obviously if there are any additional questions you guys have, certainly reach out to Dan and I. We've spent tons of time on webinars and calls with all of our partners to make sure that we are understanding these provisions and a resource for the plan sponsors.
Yeah, and Steve, Jason, and Dean, we want to just thank you again for the time. Obviously, we know your time is valuable and important, and we use your guidance to help guide our own clients here. So I also want to thank all the clients in attendance today. I know it's a real busy time right now. We will all get through this together, and look forward to actually meeting in person in the near future. So any questions, we'll be following up with all our clients in the next couple of days on all of this with respect to plan amendments. In the interim, if you have any questions that come up, please feel free to give us a call directly.
Great. Thank you all. Stay safe, stay healthy, and certainly reach out.
Thank you, everyone.
Have a good afternoon. Take care.
Thanks, guys. Bye.
Okay. Bye-bye.